Welcome back. Today, I want to talk to you about something that most fashion and beauty founders completely overlook, may not even know anything about it, may not have given any thought to it, and it could be costing you real money. And what I'm talking about is using your intellectual property strategically to increase your company's valuation. So, why is IP the dominant value driver for your business? According to Ocean Tomo's 2025 Intangible Asset Market Value Study, which is a mouthful, intangible assets now represent approximately 92% of the market capitalization of S&P 500 companies. In 1975, that number was 17%. So the relationship has completely inverted over the last 50 years, which means your intangibles, which include your intellectual property, are absolutely the most valuable assets you have in your business. So I want to give you some examples. In May of 2025, Elf Beauty acquired Hailey Bieber's skincare brand Rhode for $1 billion. Rhode had only been in existence for 3 years, and the valuation was driven by brand equity, trademark ownership, which is vital, and the defensible market position that the Rhode name had built in that short amount of time. And that is the power of intellectual property done right. Now, of course, that's a celebrity-led company. So her famous profile also helped accelerate that process. But it's the IP that is so valuable. Patent owning startups are more than 6 times more likely to attract venture capital investment. Again, intellectual property attracts investment. Investors are drawn to businesses basically with defensible assets. And when I say defensible, I mean you own them and you can protect them against the world, like a patent or a registered trademark or a registered copyright. And investors are drawn to companies with defensible assets because defensible assets create what are really competitive moats. If you think about like a castle with a moat around it, and competitive moats protect returns. What do investors actually examine in intellectual property or IP due diligence if they're looking to invest, for example? First, trademark registrations. Investors want to see that your brand name, logo, tagline, and any other key brand identifiers are federally registered with the USPTO. Now, they may also want to see it registered in other countries, depending on where you're operating. So this is not just that the trademarks are in use on the products. It's not that you've just applied for registration. You want to make sure that you have a fully registered trademark or service mark in the marks you're using in your business. So a completed registration provides nationwide priority, access to federal court to get remedies if somebody's infringing on your mark, and it gives you the ability to potentially get what are called enhanced damages, so that if somebody is infringing on your trademark deliberately or intentionally, that means times 3. So the standard measure for remedies in trademark infringement cases in the US is what's called disgorgement of profits, meaning if the other party was profiting, their net profit from your activities, from your IP, from your trademark, then you can basically force them to hand those profits over to you. If they did it intentionally and you can prove that, you potentially have the ability to get that number multiplied by 3. Those are called enhanced damages, or in the trademark case, treble damages. So that's major. And that's the reason that's important is because it also creates a huge disincentive for somebody to infringe on your mark. So getting registration creates that competitive moat, and it disincentivizes people from attempting to steal it. Second, the next thing that investors are looking for is chain of title. So an investor's legal team is going to trace the ownership of every piece of IP back to its origin. Who designed your logo? Who built your website? Who wrote your copy? If any of these people were independent contractors and there was no written agreement on file assigning the intellectual property rights to your company, you have a problem. Under US copyright law, a work created for an independent contractor belongs to the contractor, not to the company that paid for it, unless there is a written assignment or what's called a work for hire agreement. And that needs to be in place at the beginning of the relationship, ideally. I have worked with many, many founders who realized during due diligence preparation that their logo, their website design, significant portions of their content were technically still owned by the freelancers who created them. So this is a big problem that you need to fix before you are looking to attract investment or potential acquisition. Here is what I call the IP assignment problem in fashion and beauty. And this is especially common in the fashion and beauty industries where founders often work with freelance designers, photographers, content creators from the very beginning. Think about a beauty brand that's launching on Instagram, which is honestly pretty common. The founder hires a photographer to shoot product flat lays. A graphic designer creates the brand identity. A web developer is hired to build the Shopify site. A copywriter might be hired to create the product descriptions. Each one of these people may own the work that they produce if they're an independent contractor. If you didn't get the right agreements in place when you hired them as contractors, the fix is simple. And ideally, before the contractor starts work, you're going to have them sign an agreement that includes IP assignment clause or work for hire clause. Work for hire just means that they are working for you and they're acknowledging in that clause in the contract that anything they're creating on your behalf is automatically assigned to you. And you want to also have it identified in your representations and warranties section of the agreement. Once you do it, you can use it for every engagement going forward. So having a template for this type of agreement is really important. I create these for my clients all the time. But if you didn't get this in place before the work started, you can always go back and get them to sign an assignment after the fact. Now, sometimes you're going to have to pay for those additional rights if they weren't given. You need to do that, and having a good trademark lawyer or IP lawyer to assist you in this negotiation is really vital to make sure it's done correctly. But it is something that you can take care of after the fact. Okay, so then let's also talk about trade secrets, because this is an overlooked asset class, which is a form of intellectual property. A trade secret is basically any information in your business that derives economic value to your business from being kept secret. So this can include anything from customer lists, pricing strategies, supplier relationships, proprietary formulas or recipes, internal playbooks, even the fit. Maybe you have a signature fit for your apparel line that can be proprietary. Trade secrets are valuable precisely because competitors do not have access to them and would like to, because they would give them the ability to compete with you more aggressively. Another type is, you can think of Coke's formula for original Coke is obviously a trade secret. And so that's a really good one to think of because nobody has access to that. And those who do are probably a pretty small number within the Coca-Cola company. But you only have legal protection if you're actually treating that information as secret. So there's a whole process that goes into how do you protect trade secrets in your business. You need to have internal policies that talk about this. You need to have agreements signed by your employees, and you need to have a way this secret information is handled so that not everyone in the company has access to it and that it is kept under password or lock and key, something like that. And investors also want to see non-disclosure agreements with employees and with contractors. They want to see access controls on sensitive files like passwords. There need to be onboarding and offboarding procedures relating to it. And as I mentioned, a trade secret policy in your employee handbook. And this is something I also do all the time for my clients. It's vital because if you don't do these things, they will not be considered trade secrets and it will be harder to keep them confidential. So let's talk about how you can use your intellectual property as leverage in funding negotiations in particular. A clean intellectual property portfolio tells investors that you have built something defensible and valuable. And it also gives you leverage in acquisition conversations. So we're going to use an example I've used in another video about the company Skims. Skims is now valued at over $5 billion. They just did a recent round of funding. I think it was their fourth or fifth round of funding, $225 million in November of 2025 that they raised, which increased their value to $5 billion. And that valuation is built on brand equity and intellectual property that is well documented and legally defensible. The other leverage that IP gives you is through licensing. And this is one that is often overlooked and it can be extremely powerful. Once you have a registered trademark and a strong brand, you can license it to other parties. And the brand licensing market exceeds $314 billion this was in 2025, according to industry reports. So that's not a niche strategy. That is a primary strategy for a lot of companies. North America alone holds over 42% of the global licensing market. So when you think about it, there are major brands like Disney that licenses their trademarks to other companies to be affixed to certain products. So they're getting royalties from those product sales, but they're not the ones that are actually manufacturing and selling and distributing those products. Marvel, DC Comics is another one, and even sports teams, for example, great licensing opportunities. There are great opportunities. Martha Stewart is another one I can think of that does a lot of licensing and makes a lot of money off of that. Those are just a few examples. Let's talk about how you get this dialed in for your business. And the way you do it is through what I call an IP audit. So let's talk about where to start with that. First, you need to inventory everything in your business. So that is trademarks, copyrights, trade secrets, proprietary processes, domain names, social media accounts, content libraries, anything you have that could be considered intellectual property. Second, you want to check the documentation. So you want to make sure that you've got a clear chain of title from the creation of that item to the current day. Your company needs to be the one that owns it. If it doesn't, you need to solve those chain of title problems. Same with trademarks. You also have to trace the chain of use back to the original use of the trademarks. If you purchased a company and you're using a trademark that belonged to that company, you need to make sure that within that purchase of that company was the trademarks and the goodwill associated with them. There's a lot to think about, but you need to check the documentation. And then third, you need to fill the gaps that you find. Every gap you close before due diligence starts from an investor, from a potential buyer, is a conversation you do not have to have with a skeptical investor's or purchaser's attorney. So these are vital things to get under control and really understand now before you are in those conversations. Fourth, you want to build the story. So investors want to understand how your intellectual property connects to your business model. How are you monetizing your intellectual property? Fifth, you want to keep it current. So you got to make sure that your IP audit is something you do on a regular basis. It is not a one and done exercise. It's important to start and do it, but it's something you need to do on a regular basis. I would say at least once a year, if not maybe every 6 months. Obviously, there's a cost involved in getting your IP in order, but it is a fraction. And I assure you, clients who've been through this on the wrong side of it would tell you it is a fraction of the cost of losing value because you did not take care of it. My advice to you, if you haven't done it yet, and this applies to small businesses as well as growing or large companies, start the audit now. It doesn't matter where you are in your business, start the audit now, not when you have a potential deal on the table. Now, every business is different. The specifics matter. And if anything in today's episode hit close to home, I want you to know I do offer a free consultation. We can sit down together. We can look at your specific situation and figure out exactly where you stand and what your next step should be. And I do offer IP audits for my clients as a regular service, but there's no pressure, no hard sell. I'm happy to just have a real conversation with you about your business, about what you need to protect it. And you can book that anytime. Just go to my website, leveragelegalgroup.com, and I'll look forward to having that conversation. So I hope this was helpful, and I look forward to seeing you next time.